أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم. الحمد لله والصلاة والسلام على رسول الله. Welcome again. I welcome you all once again to the video lecture series, lecture number 6 of business law, and lecture number 3 of chapter number 3. Today's lecture will have discussion on acceptance and its essentials. So let's go ahead and start. What is acceptance? According to section number 2, acceptance is basically a promise, right? So when the person to whom the proposal or offer is made shows or signifies his assent or agreement or willingness upon it, this proposal is said to be accepted. A proposal, when accepted, becomes a promise. So acceptance is what? Showing the willingness or agreement against a promise, against an offer or to an offer is called acceptance. Showing the willingness to an offer made by another person is called acceptance, right? In simple words, what is acceptance? Acceptance is when an offer is made to you and you show the willingness against that offer or to that offer. This is called acceptance, right? So when an offer is accepted, it becomes a promise. The person who accepts the offer becomes a promiser because he gives a promise. Accepting of the offer is a promise. And when you accept the offer means you make a promise, and the person who makes the promise is called promiser, and the person to whom the promise is made is called promisee. So let's talk about the essentials of valid acceptance. There are 7 essentials of the valid acceptance. Means the acceptance is valid, correct, if these 7 essentials are met. The first one is acceptance by offering. The second one is absolute and unconditional. Means the person to whom the offer is made should give the acceptance. The person to whom the offer is made should give the acceptance. If anybody else to whom the offer is not made gives acceptance, that acceptance is not accepted by the law. That is neither an acceptance and nor a promise, right? Absolute and unconditional. When we accept the offer, we have to accept an offer absolutely with all the conditions, and we cannot add any other additional conditions to that offer. So we have to accept it absolutely and unconditionally. If we accept one condition and put another condition, that offer is not, it's not called acceptance. Neither is acceptance nor the offer is valid for us. Prescribed manner. We have to accept the offer according to the prescribed manner given to us by the offerer. The way we are required to accept the offer, we have to accept the offer in that prescribed way. Communication with offerer. When we accept the offer, we have to communicate our acceptance with the offerer. If we do not communicate the acceptance with the offerer, this acceptance is not valid and not accepted by the law. Express or implied. The acceptance could be expressed through spoken words or written words. Similarly, it could be in action, by conduct of the parties, by circumstance, right? So, an offer can be expressed, an acceptance can be expressed or implied. We'll talk about in details about the express or implied offer and other things in details later on. Acceptance after the offer means first you have to receive the offer, then you have to give acceptance. Before an offer, right, the acceptances cannot be given and is not valid. Reasonable time. The acceptance should be given within the reasonable time. That time should not lapse. If you take more time in giving the acceptance, right, so that more time taken, the offer revokes. So So a revoked offer cannot be accepted, and your acceptance is not a valid acceptance, right? So now let's go ahead and talk about the details of each one. Acceptance by offer. An offer can be accepted only by the person to whom it is made. It cannot be accepted by another person without the consent of offerer. When an offer is made to a particular group, it can be accepted by any member of that group. If the offer is made to the general public, it can be accepted by any person who has the knowledge of that offer. So the offeree, the person to whom the offer is made can only accept the offer. Everyone or anybody cannot accept the offer. We have to look at the offer. If the offer is specific, that specific person should accept. If the offer is specific to a group of people, so only anyone from that group of people or all people from that group can accept. If the offer is to the general public, so anyone who has the knowledge of that offer from the general public can accept the offer. Anyone having no knowledge of that offer cannot accept the offer, right? Now, absolute and unconditional. For a valid agreement, the acceptance must be absolute, means complete or fixed, and unconditional. The offeree imposes any condition in his acceptance. If the offeree imposes any condition in his acceptance, it is not a valid acceptance, but a counter offer. So I told you earlier that when you add another condition, so the first offer revokes, that offer cancels. Now you make another offer. It's not acceptance, it's basically an offer when you put another condition. So this acceptance is not valid. You have to accept absolutely and unconditionally, right? There is no contract until the counter offer is accepted by the original offer. So that is about the absolute and unconditional. Now let's talk about the prescribed manner. If the offerer prescribes a particular manner of acceptance, it must be given according to the particular manner. If the offerer may reject it, if no particular manner is prescribed in the offer, then acceptance should be made in a reasonable manner, right? Some offers has prescribed manner for its acceptance. So when an offer has a manner for acceptance, so the offeree or the person who accepts the offer should follow those prescriptions, those guidance, and according to that guidance present his acceptance. If the offer does not contain any prescribed manner, then we have to follow the reasonable manner. An irreasonable manner should not be followed, right? You have to look at the circumstance. According to that, in a reasonable manner, in a reasonable way, we have to show our acceptance. Okay. There are examples, very easy examples. You can read it from the slides that I've shared with you easily. I'll read one of the examples from here. Example number 2. Ahmad offered to buy goods from Bilal and requested to send acceptance by messenger who had brought the order. Bilal sent his acceptance by post, thinking that this would reach to Ahmad earlier than messenger held. Ahmad was not bound by the acceptance. Ahmad said that you have to send your acceptance and via messenger, the person who brought the offer to you or the order to you. But Bilal sent his acceptance by the post, so he does not follow the prescribed manner given by the offerer. Therefore, the acceptance is invalid and Ahmad is not bound by this acceptance, right? Communication with offerer. The offeree must communicate the acceptance to the offerer in a clear manner, showing the intention to accept an offer is not valid acceptance. If offeree does not accept the offer, no agreement is formed. When offeree accepts the offer but fails to clearly communicate, it's not considered acceptance. So we have to here keep in mind that when we accept the offer, we have to follow the prescribed manner at first place. Number 2, when we have accepted the offer, we should not keep this acceptance limited to us. We have to clearly communicate this to the offeree, to the person, to the offerer, to the person from whom the offer came. We have to communicate, right? By just showing the intention, acceptance is not valid. Acceptance cannot become a valid acceptance. Maybe you have accepted, but you have not communicated with the offerer. When you have not communicated this offer, this acceptance is not valid acceptance. You have to after you have accepted with yourself, you have to communicate it through proper channel. You have to let the offerer know that his offer has been considered and accepted. If you do not communicate your acceptance with the offerer, this offer is not considered to be valid acceptance, right? For example, Ahmad offers by a letter to purchase Bilal's house. Bilal expresses his intention to sell it but does not reply. Bilal sells his house to C. Ahmad has no legal remedy against Bilal, right? For example, I sent you a letter that I want to sell, I want to purchase your house, right? And you does not reply to me. You say, you accept my offer, but you do not reply to me. So after you did not reply to me, I purchase another house from another person because you did not reply. So then later on, you cannot tell me that I have accepted your offer. Why have you not bought my house? Why have you not bought my house, right? Because you have not communicated your acceptance with me. Therefore, I am not bound by your acceptance, even though you have accepted but not communicated to me, right? So that's why when you accept the offer, you have to communicate it with the offerer. Number 5, express or implied. When an offer is given by words spoken or written, it's called express acceptance. When it is given by conduct or action, it's called implied acceptance. If the offer is made to the public and the contract arises when person accepts it by word or conduct. As we can have an express offer and implied offer, similarly we can have express acceptance or implied acceptance, right? For example, a widow promised to give some property to her niece if she stayed with her. The niece stayed in her residence till her death, held that niece was entitled to the property. This is action, right? Similarly, Ahmad offered by letter to sell his motorcycle to Bilal for 10,000 Afghani. Bilal accepted his offer and sent a letter of acceptance. It's called express acceptance. So acceptance can be by action, by conduct, or it can be by written words or spoken words. Next, we have acceptance after the offer. Remember that before the offer, the acceptance is not valid. We cannot accept. There should be an offer, and to that offer there should be an acceptance, right? For example, sometimes it happens that there is an organization who is to make an offer. Before announcement of the offer, the information leaks to other person, and that other person sends his acceptance, right? And claims to buy or to be entitled of that thing. This does not happen. Law does not allow this, because the offers should be accepted after the offer, right? The acceptance should be given after the offer. When offer is not made, how can you accept? It's not possible. Acceptance must be given after receiving an offer. If cannot precede the offer, it cannot precede the offer. If acceptance is made without having knowledge of offer, there is no contract, because no acceptance can be made without an offer. For example, Ahmad offered a reward for anyone who finds his lost documents. Bilal, an ignorance of the offer finds and returns the document, we cannot claim the reward. Because what is here? Because offer is not communicated with him. He does not know that there is an offer for me, right? So if there is no offer, how he can accept that, right? Or for example, before the offer is made, he has found the document, right? And then when offer is announced, he returns so that he can accept the offer. It is not possible as well, right? So there should be first an offer, then there should be an acceptance. Also, the offer should be communicated with the offeree. Without communication, if the offer is not communicated with me, how can I accept that offer? Understood? There was an example earlier in previous lecture that I had, and I explained that example, how communication of the offer and communication of the acceptance is important. Next is reasonable time. We have to communicate our acceptance within reasonable time. When an offer comes to us and that offer has a limited time, we have to show our acceptance within that limited time. If an offer comes without any specific time, then we should be reasonable in showing our acceptance to that offer. We should not take longer, because if we take longer, the time lapse. When the time lapse, offer automatically revokes. When offer is revoked, we cannot accept that revoked offer, right? There is an example. Mahmoud applied for shares of a company in June, but allotment was made in November. Mahmoud refused to accept the share. It was held that Mahmoud could refuse to take shares because offer has lapsed the time. After the expiry of reasonable time, this is a practical example. June and November, there are like more than 5 months. There is more time, right? So the time should be, even though this offer does not have limited time, but this time is not reasonable time. It's taking so long. That's why the offer has already revoked. So therefore, it cannot be accepted, or acceptance cannot be given by taking longer time. So that's all for today. In today's lecture, we had discussion on the acceptance and the essentials of the acceptance. What were the essentials? There are 7 essentials. Number 1, acceptance by offering. The acceptance should be absolute and unconditional. The acceptance should be according to the prescribed manner. The acceptance should be communicated with the offerer. The acceptance could be expressed or implied. The acceptance should be offered the offer, and acceptance should be given within reasonable time. That was our lecture today. In our previous lecture, we had discussion on the offer and the essentials of the offer. There were 7 essentials. That offer could be expressed or implied. The offer should be for legal or business relations and should give legal obligations. The offer should be definite and clear. The offer should be for could be specific to a person or to a group, or it could be general to public. Offer should be communicated with the offeree. There should be no negative conditions in the offer, and we could have positive conditions with the offer, right? And how can we revoke or cancel the offer? There are 10 different ways, right? Number 1, notice of revocation. Number 2, lapse of time. Number 3, failure to fulfill condition. Number 4, death or insanity of offer. Number 5, revocation of offer by the offeree. Number 6, counter offer by the offeree. Number 7, death or insanity of the offeree. Number 8, subsequent illegality. Number 9, destruction of subject matter. And number 10, prescribed manner. So these are different ways where an offer automatically revokes or cancels, or we can use one of these ways to revoke or cancel the offer, right? So that's all for today's lecture, and this is the end of chapter number 3 as well, and end of our today's lecture. I hope I have delivered the lecture of this chapters in an easy way, and helped you guys to understand the topics and the explanation that I've made. Even if you have any questions require further explanation, I'll be more than happy to help you. Please get back to me via WhatsApp or maybe via email. I'll be more than happy to help you, right? So thank you very much for being with me. Inshallah, see you in the next lecture. Bye for now.